Hi, welcome back to HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate at MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. Great to be with you.
Well, thanks for being here again.
Thank you.
Today, we're going to talk about something that you and I see all the time. It's extremely common. Now, we've touched on this issue on multiple occasions because it hits so many different avenues or aspects of HOA life, okay? Mm-hmm. But today, it's what happens when HOAs ignore common areas. They ignore their obligations to maintain, repair, replace, okay? Leaking stairways, leaking balconies, broken or cracked stairways, leaking roofs,
huge.
Old pipes, just any place where you have common area that isn't being properly maintained or properly taken care of by HOAs. Mm-hmm. Now, we talked about in our two-part episode we just got finished with, we talked about how the embezzlement issue was not an epidemic.
Right.
Okay. Mm-hmm. But it's frequent. It happens a lot just based on human nature. Mm-hmm. This is an epidemic.
Oh, absolutely.
Okay. Mm-hmm. This is an epidemic. This is an example of a epidemic failure on the part of so many thousands of HOAs throughout the state of California that it's worthy of epidemic status, at least in our field. Mm-hmm. Okay. So this failure to maintain. Now, maintaining includes everything from making basic repairs to doing spot checks to actually preventive,
right.
Painting where the paint has gone off, painting something so that it has sun protection and it has rust protection. So it's that failure to fix something that's already broken or to prevent something from becoming broken. Mm-hmm. That's what we mean, okay, by failure to maintain. And that's what is epidemic. Mm-hmm. And we're going to talk today about how that manifests, why HOAs seem so reluctant to maintain common areas. Not all. There are a lot of very good HOAs out there. I live in a good HOA because they fix things that are broken, and they fix them pretty quickly. I don't live in a multi-family condominium or a multi-family unit like a condo or a townhome. So there's probably less opportunities for common areas to go wrong, but we have plenty of common areas. We own the streets. We have gates. We have cameras. We have greenscape and landscaping. And, when stuff cracks, something goes wrong, and they're always out there fixing it, There's a crack in the street or a pipe leak, they're there fixing it.
Nice.
So that's the way it should be. Mm-hmm. So I've been lucky. I'm lucky. I live in a good HOA. But there are plenty out there, and there are enough we're calling an epidemic.
And that's what you sign up for when you get into this community style living, and for them to preserve property values.
Right. And here's the thing. We spend a lot of time in this show talking about how, all the problems with HOAs. The concept of an HOA is a good thing. I would rather live in a good HOA than not live in an HOA at all. Mm-hmm. But I would rather not live in an HOA than in a hellish HOA. Oh, yeah. Okay? Mm-hmm. So the goal really should be, let's make HOAs good. And that's what we try to accomplish in this podcast, okay? HOAs as a principle, I think, are good things. They help maintain property values. They prevent you from having to deal with a neighbor that is playing music at 11 o'clock at night, and you don't necessarily want to call the police and instigate like that. Or the neighbor from storing, a broken RV on their front lawn, or painting their house purple, or a variety of other things that would bother us.
Right.
It helps avoid those things. That's a good thing. But when you put people in the mix and people have egos and you start getting personalities and just, again,
it gets messy.
It gets messy and things start infiltrating into the relationships that shouldn't even be part of them.
Right.
So part of what we're going to talk about today is we got to kind of define some terms. We're going to tell you what common areas are. So we're going to talk to you about what the common area is. Mm-hmm. We're going to talk to you about what California law mandates on the part of the HOA when it comes to common areas. We're going to talk to you about real life examples about boards who drag their feet or utterly ignore known safety risks, okay? And what the consequences for that are. And then ultimately at the end, how to hold your HOA accountable when they are guilty of failing to maintain common areas. Because of all the things that come into our law firm, failure to maintain common areas is among the top 2 complaints that we get.
Oh, absolutely.
It might be mixed with other stuff too.
All the time. Crossovers, yeah.
But boy, oh boy, that is at least in the top 2. Meaning every single day we have a new consult because we consult with multiple people every day. Our lawyers meet with new, what we call potential clients, PCs, every day. And I would say more than one of those every day, failure to maintain is in the mix.
100%.
That's why we call it epidemic, okay? So let's talk about what the common area. Talk to me about what is the common area, and please, while you're doing it, I want you to differentiate it from, I want you to explain quickly the difference between common area and exclusive use common area, because they're both common area.
Right. So in basic terms, common areas are in multi-unit dwellings like condo communities. It's anything outside of your unit. This could be a shared roof, shared exterior staircase. We're talking about any amenities. We're talking about green belts, shared parking spaces or garages, and components such as that.
Parking structures are
correct.
Okay.
And
Elevators?
Elevators as well, of course. I mean, when I meant amenities, things like a gym, could be some kind of a laundry room, could be a clubhouse, tennis courts, pickleball. Right, especially if it's exterior, right? And to briefly distinguish that from the exclusive use common area, that could be a balcony or patio that is specifically and exclusively pertaining to your unit, although it is technically part of the common area, but the maintenance of that could be ascribed or attributed to respective unit owners.
with respect, so we're not going to discuss balconies today because we have a whole other episode on that, and it's a unique animal because balconies are almost always exclusive use common area, and homeowners in most of those places that have balconies, that have exclusive use common area balconies, have to maintain and keep it clean and stuff like that and waterproof it. But when it comes to systemic problems, they have to be rebuilt or restructured, that is up to the HOA. Right. So we're going to skip balconies today. We're going to skip that, okay? But yeah, all the stuff that is a part of your unit, whether you live in a single family dwelling or you're in a townhome classified as a condo or a condo, if it's not part of your house or unit, depending on what you've got, it's common area. So in a single family neighborhood, you might have tennis courts, you might have roads, you might have a guard gate, you might have cameras, you might have slopes and landscaping and retaining walls. Or in condos, you might have lobbies and hallways and elevators and staircases and the roof and the walls on the outside and the windows. They might all be common area. So that's what we mean when we talk about common area. Now that you guys understand kind of what we're talking about when we talk about common areas, let's talk about what the law requires when it comes to common areas. And there's always an exception. So we're going to skip the exceptions. We're talking about the vast majority of the time. We're going to talk about the rule, not the exception. So this is governed by Civil Code 4775. Right. It's not a complicated statute, and it's not a long statute. It's pretty basic.
Basic, straightforward.
Bottom line, all you need to remember about 4775 is the HOA is responsible to maintain, repair, replace common areas.
That's it.
That's the law, okay? For the purposes of our discussion, that's the law, okay? And that obligation exists whether or not it's expensive, whether or not the HOA wants to spend the money, whether or not the HOA has budgeted for repair, replacement, or maintaining of that specific element of the common area. If they forgot to budget for it, well, that's a breach of fiduciary duty and negligence. Well, it might be a breach of fiduciary duty. It's certainly negligence. But whether they budgeted for it or not, it doesn't matter, okay? Whether or not they deem it urgent enough. In other words, well, when it's starting to break, talk to us. But right now, we're skipping it. I'll give you an example. The paint is peeling on the metal fences surrounding your pool, okay? Your community's pool. Well, rust eats metal away over time until the gate no longer is foundationally structural. And the reason these pools have gates surrounding them, in addition to keeping people that don't live in the community out, is because California law requires them to be gated because of drowning and children. So when you have a gate that is teeter-totter, kids can get into it. Bottom line is, it's not okay for the HOA to say, well, the gate's structurally sound, but yeah, there's rust all over it and we can see there's some holes, but we've got some time. No, they have to maintain it. Not just replace it, not just repair it. They have to maintain. Maintaining includes painting it every so often. Right. And we've talked in past podcasts about the life of an asset. Right. And one of the things I remember from previous publications, in the what the experts talk about is that every 2 years, exterior metal gates should be painted with the proper paint every 2 years. That's what it used to be. I don't know if it's been updated, but that's what it was last time I looked. Well, if you don't do that and it starts degrading,
Right.
they have to fix it then, not go, well, talk to us when there's holes in it. That's worse, but that doesn't make what they're doing right, okay? So they don't get to pick and choose which maintenance obligations they're allowed to engage in. They're supposed to maintain, repair, or replace, whichever of those three is required at any given time, every single bit of common area that exists, period. That is one of their fundamental duties.
Right. Mm-hmm.
Right?
100%.
Okay.
Yeah.
So how do these failures, let's talk about how some of these failures typically manifest in real life, okay? I'll get you started, and then you come up with one, okay?
Okay.
Leaking roofs that haven't been repaired in years and years and years, okay? So what happens? If you live in a single-family home, this doesn't apply to you because the roof's not common area, it's yours. So I'm speaking about townhomes classified as condos or condos, okay? So you were in a unit in your condo and you notice water intrusion. So you get immediately you act, okay? You get your contractor there. Contractor opens up the wall, dries everything out, looks up and is able to trace some of the leakages. Well, it's not coming from a pipe here. It's coming from above you. Depending on where you're situated in the building, it could be the unit above you, in which case, without access to that person's unit, he might not be able to tell you. He or she, your contractor might be able to tell you where it's coming from, because ultimately it could be coming from higher than that, or from that person's leaky pipe, where their bathtub is. But if let's say you're on the top floor and the roof's above you and it's coming from above that, then it's going to be the roof, right? Which you don't own and you don't control and you can't repair. So what often happens is you have these homeowners that are having these leaks, and for whatever reason, the trace has been done and it's from the roof.
Yeah. Mm-hmm.
So they do the best they can. All you can do is demand, right? Well, no, there's more. We'll tell you later. But in addition to that, they keep repairing it themselves at their own expense, by the way. Now, we've talked about this before. If ultimately you decide to pursue your HOA, and this is something that they've ignored in the past, and this is now, let's say, your second or third time dealing with a leak, well, at that point, I say they are paying all your bills. Okay?
Agreed, yeah.
And we've talked about that. They're not liable for your personal property or what's in your unit unless it's a result of their negligence and failing to repair when homeowners have said this is a problem and then not doing anything and then it happens again. That's negligence, and that's why they're going to be responsible for every dime of your damage, and we'll make sure that they are. But here, let's just say it's the first time, okay? So the leak's coming from the roof. You're not allowed to fix it. They have to fix it. So you do the normal thing. You go and you claim. You say, hey, help me out here, okay?
Yep.
So that's how, leaking roofs result in homeowners having leaks in their own units.
That's a huge common one.
What's another one?
Another one is rotted or compromised walkways or stairways.
All right, cracked too.
Cracked,
Okay.
There's a hole, someone, trips, falls, there's an injury. That's a big one. And this happens more often than...
And what do some HOAs say in response to that? Some HOAs will write on it and they fix it, right?
Yeah.
Good HOAs.
Right.
They fix it because they know that it's a tripping liability.
Got it investigated.
Somebody could get hurt.
Yep.
Okay.
Yep.
But what do the bad HOAs do?
Well, they deny, deflect, delay the process. They don't duly investigate it. They say it's too expensive. It's not an emergency. And they basically punt. They kick the can down the road.
Yeah. The walkway's not in danger of being tagged at all.
Or we looked at it at this point.
Yeah,
Someone
there's a little crack
there.
there. People just need to be more careful.
Downplaying it,
right?
Essentially.
Exactly.
Yeah.
Okay. Downplaying broken and cracked staircase or any elevated element.
Which is...
Yeah. We'll talk about liability later, but you can't do that, folks.
Yeah.
Let me explain something to you. Just because the crack or maybe the raise or the increase in height, right, is minor, it only takes an inch to cause somebody to trip. Just enough to catch your foot on.
Mm-hmm.
Okay? A trip, depending on who's falling, could be nothing. 7-year-old kid falls, big deal.
Or it could be devastating. Yeah.
Or it could be life-changing. If you're a senior citizen, you've broken a hip, and that leads to all the other things that forced bedriddenness leads to, right? I mean, it could have monumental consequences, okay? Yeah. Another one that we see a lot, and we're going to only name it here, but we're not going to go into detail because, again, we've talked about balconies, but rotting and endangered balconies. The whole balcony law exists because of this issue. Right. The balcony law that we talked about in our second or third episode of this podcast exists because of this issue.
Major safety concern with
Right.
this. Yeah.
And then the collapsing balconies that have occurred not only in California that precipitated our law, but then years later, the one that a few years ago that happened in Florida. Okay.
Mm-hmm.
And then, of course, another big one is you see this especially, well, I won't say especially. You see this a lot in Southern California, maybe in Northern California. I don't live there. I only lived there when I was in college, and that was at the university, so I don't know. But slopes. Okay, wilderness areas, so retaining walls and slopes.
Yeah.
Guys, we live in California. We have earthquakes, even if you don't always feel them. I'm going to let you know on a secret, okay? Land shifts all the time. Now, it shifts a lot more than others. Anybody that lives in Palos Verdes, especially the peninsula side of Palos Verdes, okay, over by the Trump Club and right, that road shifts constantly. So they're redoing it every month or two. It's constantly undergoing road work because it shifts literally on a daily basis. Not everybody is that bad, but land shifts. Earthquakes shift things. Erosion shifts things, okay? So retaining walls are going to crack. Slopes are going to move in a way that maybe they didn't anticipate, and it causes damage because shifting earth cracks foundations. It is a trickle effect, okay?
Right.
So what we find in many cases is HOA becomes aware of it. Well, we're monitoring the hillside. So they give you these trite little phrases. We're monitoring the hillside. We're investigating. We're on top of it. But you never see anybody out there doing anything. So nothing's changing.
Right.
That retaining wall that's holding that slope is cracked, and it still remains cracked. And the crack's getting bigger.
That's a huge one, too, in terms of possible property damage, but also personal injury risks.
Let's go to the property damage for a sec. I mentioned a minute ago, cracked foundations, right? If your house happens to be in that line of crack where the slope is, the crack in the slope is spreading upwards and downwards, it's moving like in a line, right? And I don't know how many people have ever had to replace their foundations, but it's very expensive.
Yeah.
Okay. Now, your insurance probably covers it, but that doesn't mean your insurance is not going to go up. Okay. And you're going to have to deal with that. You shouldn't have to deal with it. You shouldn't be popping your insurance for this. It shouldn't. It shouldn't happen. But that's what we hear a lot.
And with much of that is a stitch in time principle. Get ahead of it because the pound of or an ounce of prevention, right?
Right, or penny wise and pound foolish.
There you go. Yeah,
right. Same thing.
Yeah.
They all mean the same thing. Take care of it now. I guarantee you, taking care of it later is always more expensive.
Oh yeah.
It's always easier to maintain than it is to repair, and it's always easier to repair than it is to replace or rebuild. That is a rule in the world that you should. It is a standard, and
right.
It always is true.
Right.
Maintain is better than repair. Repair is better than replace or rebuild.
Right.
Always.
And delayed is not only expensive, but also gives rise to foreseeable claims and
negligence and fiduciary breach and non-covered. We're going to get into this later. What happens when it's a known defect and somebody does take action and then it's discovered that the board sat on it? Now we're in punitive damages potential territory. Right. So we'll talk about that in a minute. So the last one I can think of on my list here would be floods, flooded garages.
Drainage issues.
Right.
Yeah.
Bad drainage, clogged drains, old pipes that are rotting or clogged and haven't been snaked or cleaned out or maintained.
Right.
Any kind of flooding like that, other than a flood caused by an act of God. You had a fire on the slope, you had mud, you had a rain, caused a mudslide. That's not what we're talking about. That's not. That is an act of God. That's not an example of a defect or failing to maintain. Right. Water carved out the Grand Canyon. It can certainly carve out your slope in one night if you have a serious enough flooding.
Yeah.
Heavy enough rains, you could have huge gouges carved into your slope. That's not an issue that the HOA can be blamed for. What the HOA can be blamed for is if that happens and then they don't do anything about it, and then somebody's house. That's the problem we're talking about. Okay, so flood and bad drainage. Okay, so water intrusion. Okay.
Right.
These are not isolated. There are more, but those are the ones we see most commonly, right. I think, okay? And every one of these affects communities with 500, 600, 800 homes or 6 homes. It doesn't matter how big your HOA is. This is universal. It does not discriminate on size of your HOA. These things happen when failure to maintain happens. It doesn't matter how big or how expensive your homes are. It doesn't matter how many people live there. It doesn't matter. It affects it all equally.
Right.
Okay? So every single one of the things we've talked about so far, other than the flood that occurred because of a huge rainstorm or a mudslide, resulted from one source: HOA negligence. Yeah. Failure to act. Failure to do one of their fundamental duties. That's the problem. Okay? So, why? When there's no upside. There really isn't in the long, even saving money, not an upside. We've already discussed. Maintaining is less expensive. Yes, everything costs money. Maintaining costs money, but it costs less money than repair. And repairing, yeah, it costs money, but it costs less money than replacing or rebuilding. So, given that universal truth, why would HOAs, even to save money, why would HOAs not do their fundamental duty and maintain, repair, replace when it's necessary? Why would they choose, because it's a choice, why would they choose to say, nah, we'll hold off?
I mean, it remains baffling, but that part notwithstanding, it usually comes down to they don't want to raise assessments.
Start with that.
Okay.
They don't want to raise general dues.
General dues.
The dues you pay every month, right?
Typically monthly dues, correct. And obviously there's a statutory limit to that, but they just simply don't want to do it. Oftentimes out of...
They don't want to pay more.
Self-centric interest too, because these are homeowners, volunteers on the board. They don't want to pay more.
Yeah. Let me ask you about that.
Yeah.
We've discussed ad nauseum in this episode that repair is better than replace, or repair is better than, or maintain is better than repair. Repair is better than replace.
Right.
But not everybody has ever thought that through. Some people haven't thought that through.
No.
So would you agree that I don't want to raise assessments and I don't want to pay? I'm paying $250 a month right now and I don't want to pay $300 a month or $400 a month. So I'm going to keep this down and so I'm not going to have the money. Would you agree that some directors believe they're actually saving money doing that?
Oh, 100%. It's. I mean, that's what they believe. We've heard them say this before,
but it's wrong, isn't it?
Having been on the other side representing HOAs previously, as you know, I saw that consistently, and they think they're doing God's work
for their own people.
Right. So
some of them do. The good-natured ones think they're actually helping.
Yeah.
But they haven't been educated.
No. And it's really...
That's the manager's job.
That's a broadly shared temperament and impulse, unfortunately, but it's so short-sighted, right?
Right.
Because for the reasons we discussed. And
penny wise,
right.
Pound foolish.
And that makes no sense. And so that's where it's really paramount that they get some decent guidance.
Which they don't.
So
let's go to that next one. You were about to mention. I think you were going to go with assessments. Okay.
Special assessments.
So remember, special assessments are those assessments that come up, pop, boom, everybody's got to give us a check for this much.
Yeah.
So you're paying all your dues. Oh, and write us another check. Okay. Now, if it's under the 5% threshold, it can be decided purely by a vote of the board without your participation. Or if it's over that 5% of the budget threshold that we've talked about in the episode on special assessments, then it's got to go to a vote unless it's an emergency, and we've talked about that too. We don't want to specially assess, and we don't have the money in our budget right now.
Yeah.
And we're not going to mention the other account because we're about to get to that. But we don't have the money in our budget, or we don't want to spend it, and we don't want to raise, and we don't have it anyway. And even if we raise general assessments, it would take time to build up enough money. And I don't want to specially assess. So since I have no options, we're not going to do anything.
You can't have it both ways.
Yeah, you can't do that, right? But So I don't want to raise general assessments, dues. I don't want to institute a special assessment or hold an election for one, depending on the amount. And the third one, I don't want to dip into our what?
Reserves. Yeah.
Isn't that the point of a reserve account?
Exactly. I mean,
to fix things?
And all those vehicles and mechanisms are really those available and tools that the board ought to deploy.
The whole reason the reserve accounts exist is to take some of the money out of the general assessments, your dues. Some of that is used for maintenance and, weekly or daily, whatever, depending kind of housing you have, costs and expenses that come with just running the day-to-day operations. Yeah. And then some of that money is supposed to be set aside into a different account for maintaining, repairing, and replacing common area elements. In other words, some of that money from everybody's dues is supposed to be put over here and grown so that when something needs to be repaired, replaced, and there isn't money in the general fund for it, they can pull out of this. And yet these directors say, I don't want to spend this money. The money isn't there as a slush fund. No. It's not there to save up for a big end-of-year party. It's there exactly for the reason that they're supposed to spend it. Fix, maintain, repair.
we've said it here, and we have other long-form episodes on this, fleshing it out. One of the utmost and critical duties of the board is
one of the top three.
Exactly this.
Yeah.
And so,
it's the three. There's three fundamental duties that every board has to their members, and this is in that top three. This is one of them. Maintain, repair, replace the common area.
Right.
End of story.
Yeah.
It is sacrosanct duty.
And by the way, there's one other reason they don't do this, and you and I have discussed this ad nauseum too, and that's utter laziness or being uninformed. They simply,
which there's no excuse for.
I mean, that's not an excuse.
No, it's not.
No.
Okay, so we see every one of those manifested. Those we gave you 5. He added a 6th. We see those all the time. Those come up. Why? It'll come up. Let's say if there's a lawsuit or in discovery, like why didn't this get resolved, or why didn't you guys do this at this time, or what was your thought, or what was the debate and discussion amongst the board? And this is what comes up. These things. Yeah. These are the things, and not one of these that we just talked about is remotely a satisfactory answer.
No, it's not.
They are not legal excuses. The statute that we cited before, 4775, doesn't say you must repair, maintain, and replace, except if it's too expensive, or you don't feel like spending reserve funds, or you don't want to raise the set. That's not how it works. Okay? So, you have lazy, uninformed directors, which is not an excuse. You have, we don't want to raise special assessments, and we don't want to raise dues.
Right.
Those are bad excuses.
Yeah.
Okay? Now, there are, and we've hinted at this before, so now we'll get into it, there are legal consequences. Real life legal consequences for a board's decision, because it is a decision, not to act.
Right.
As they're obligated to act. Okay? So, what happens when a board fails to act? A few things, and none of them are good. Number one, most obvious. I'll use Sam's example about the broken walkway. Okay? Remember we talked about the crack.
Yeah.
Personal injury liability. Somebody, let's say in the middle of the night, there's a little earthquake. I just want to make it easy. There's a little earthquake and it causes a crack and elevates part of a walkway. The next morning, somebody goes and trips on it. I don't think the HOA is going to be liable for that legally.
Agreed.
Okay? There was no notice. There was no failure to maintain or check here. It just happened. And then somebody tripped.
Unless the prior failure was exacerbated by the earthquake.
Well, but in my scenario, it was a perfectly good thing. The earthquake caused the crack. That was my hypothetical.
Yeah.
So I'm going to stick with my hypothetical on that. Okay? So the crack occurred in the middle of the night. Next morning, somebody tripped on the new crack. I don't think the HOA is liable. It's unfortunate. Hope the person is okay, but I think their insurance is going to have to cover that. Right. Okay? And it will. Their homeowner's insurance will cover that tripping and falling. Now, the person that got injured informs the HOA, we got a crack here, it's outside my unit. You guys come by and do whatever it is you got to do to fix that. Now, let's say the HOA fails to do that. HOA doesn't do it. Okay? Now we got HOA liability. 100% liability.
Yeah, 100%.
They knew about it. They ignored it. They failed to act. And I'll tell you, ignoring it includes putting a cone there and saying, hey, warning, this is the crack here. That is expected in the short term while you're getting a contractor to come fix it.
Yeah.
An HOA that doesn't do that, I think that's problematic, but it's not. That is a temporary alerting everybody while you're getting it fixed. If 6 months down the line, the cone and sign are still there and the crack is still there, cone and sign are no longer going to help the HOA.
That's not even a Band-Aid.
It's not a Band-Aid. It's literally, it's whatever's less than a Band-Aid.
Yeah.
Okay? The bottom line is, what is a responsible good action on the part of the HOA in the first week or less of discovery of that defect becomes negligence after that length of time. What should happen is they put a cone there and a sign saying, caution, be careful, there's a crack here, and then even light it up so in the evening times people can see the sign and the cone, right? Then they get their contractor out as soon as possible to make repairs. Right. That's what should happen. And if anybody gets hurt in the interim, there's not going to be liability for the HOA. Not under the law, at least, okay? I can't speak for what juries might or might do, but it won't be, at least it shouldn't be under the law, okay? But as bad as that is, personal injury, and because that's hurting somebody physically, like causing them hospitalized or serious injury. It's not going to be as expensive probably unless there's a serious injury like head trauma and then the person's in a coma or something, and then now you could have some problems. But is the D&O insurance popping, right? Delayed action or outright negligence can trigger claims.
Right. Yeah.
And of course, that's going to go right to negligence on the part of the director, which is mere negligence is covered under directors and officers policy. So those are going to get popped. When that happens, what happens to the rates the next year?
They will almost certainly go up.
And who pays for those rates?
Everyone. The
HOA
community
pays.
Yeah.
Right? You are paying for a policy to cover the negligent acts of your elected board. Yeah. That's the way it works.
Unfortunately.
That's the law, and that's the way it works. Okay? So you're going to have D&O insurance claims. The worse your HOA is, the more of those are going to occur, and the more expensive your D&O policy is going to be.
Right.
That all of you are then going to pay for. Okay? Or let's give you an example that isn't as obvious as the crack. Okay? Let's say, back to the slope thing. You have an engineer come out and do the yearly report and says, okay, we've got some erosion and movement on slope number 2 and slope number 3, and I recommend the following.
Yeah.
Okay? And then they ignore the engineer. Say, remember, we talked in a former episode about the fact that HOA directors are shielded from personal liability if they reasonably rely on the advice of paid consultants, like their lawyers, accountants, contractors, or engineers. But the opposite is also true. If they ignore the advice of their paid lawyers, architects, consultants, engineers, accountants, and that ignoring causes damage, they're going to be held liable for that.
It's far too common and baffling that they still do this.
Yeah. And so what happens is they ignore the engineering report. Somebody takes them to task for it and pops that insurance policy.
Yeah.
And then the third one, which is very related to that second one, because that's how it manifests.
Big one.
Is lawsuits by homeowners.
Homeowners, yeah.
Okay. Lawsuits for breach of contract, for negligence, for breach of fiduciary duty, for deck relief.
Right.
It's heavy.
Yeah.
And what happens, because these are lawsuits for enforcement of the governing documents, because they're required to maintain, that's part of the CC&Rs. What happens when the homeowner wins that?
They get their attorney's fees.
Yeah. So in addition to the HOA having to do what they were supposed to do from day one, that's not going to change.
Right.
They now have to hand over a potentially lot of money, depending how far the litigation gets. It can be minimal or it can be a tremendous amount. They got to hand that over because now they're responsible, of course. Now they've written a much bigger check for something that should never, every dollar spent on the repairs would have had to have been spent, right? But every dollar spent on the attorney's fees that they now have to pay for is money thrown out the window.
Yeah.
It's HOA money that's just being burned. You might as well light a cigar with it. Okay? Or use it, make paper airplanes. Okay? Oh, and I can think of another cause of action that will accompany these lawsuits is probably injunctive relief to get a court order to force them to do what they should have done from day one.
Yeah.
So I think we've impressed on our listeners that this failure to abide by this most fundamental duty is extremely expensive.
Major consequences.
Right.
Yeah.
So how do you as a homeowner recognize when your HOA is in danger of being one of those HOAs that we've been talking about? What are those red flags that you can look out for that will clue you in? Are they all definitive? No. But they're exactly what we just said, red flags. When you see these, it's like somebody waving a red flag, take a second look, maybe even a third look. That's what we're going to talk about, okay? 1, you're taking a look, and I recommend everybody do this once every couple of years, but take a look at the minutes. If you don't attend the meetings, take a look at the minutes. We're talking about the board meeting, open board meetings that occur hopefully once a month, okay? If there are vague notations in the minutes, they aren't supposed to be vague, okay? If there are vague notations in the minutes about ongoing or we are continuing to evaluate the slope problem on Catacomb Way, okay? We are still discussing the slope problem with our contractor, or we are in the process or still in the process of, and it's been a few months, that's a red flag.
That's a red flag, yeah.
If the whatever was brought to their attention in March, and in April, the meeting, we're still evaluating and bidding, waiting for bidded contracts, that's reasonable, okay? But if you're now in July or August and they're still giving that message, that's a huge red flag. It doesn't take that long to get started to fix.
Yeah.
It doesn't. So vague meeting minutes or notations about ongoing evaluations, still looking at, still getting bids, and it's been months, red flag.
Right.
You agree?
Agreed, 100%. Okay. Yeah.
Failure to post or share inspection reports.
Right.
So
that's a major one.
As a homeowner that your board was walking around with some whoever, let's stay on our slopes. That the landscaper guy, because you've attended the last couple of meetings, the landscaper guy or the soil engineering guy was coming in to do an inspection, and they're doing a walk, right? That happened, and yet you don't hear anything. The board doesn't discuss, hey, everybody, we got our inspection report. It's available if you guys want it, right? You don't even hear about it. It's not reflected in the minutes that we now accept this report. Nothing. There's just no mention.
Again, lack of transparency.
That's right.
Huge.
But there's no mention.
Right.
That can mean one of two things. It can mean lack of transparency. Your board is secretive. We talked about that yesterday, right? In part two of that two-part show we did on embezzlement, where we talked about lack of transparency, because that's a red flag for embezzlement. Or it could stem from they don't have the report. Or they don't want you to see it because they're ignoring it. It's one of the two.
Something derogatory and concerning.
In my professional opinion, this needs to be addressed immediately.
Yeah.
And this is how much it will cost.
Or it may even elaborate and touch on years of neglect.
Or it might say, it appears to this expert that this is a result of X amount of years of neglect, and therefore this needs to be addressed now, or it'll get worse and worse. Anything like that, they're not going to want to share that.
No.
Okay? So if you know that there was an inspection, let's say, in this example, and there's been a failure to post or discuss the inspection report, I would be satisfied with something in the minutes discussing, we received the inspection report, and generally we were advised X. They don't have to say, and we were chastised for failing to maintain. I wouldn't say that had to be in the minutes. But what has to be in the minutes is we were advised to make immediate repairs. If nothing is said other than, well, let's say nothing is said. They don't even mention the report. That's the worst. Or they mention it, we got the report. We're looking at it. Okay, what happens next month? If you don't hear anything about it, now it falls under this red flag.
Yeah.
So we've got vague meeting minutes. We've got failure to talk about reports that would exist, right? How about we can't take care of it now, but we're going to budget for it next year?
Yeah.
I've heard that. Have you?
I have.
At that point, if that's true, and it might be true.
Right.
What are they supposed to use? Reserve funds.
Reserve funds, yeah.
Yes, it wasn't budgeted. We know that. Thank you for sharing that.
Yeah.
Maybe it should have been if it was an ongoing problem, or maybe it was new. Maybe it happened in January, now we're in July and they haven't done anything about it, so it couldn't have been budgeted the last year. But certainly, you can't wait a year. You can't wait a year for a lot of this stuff. So that's inappropriate. Right. Go to your reserves. Yeah. So that should never be an answer. So anytime you hear that, if it's a minor thing, the roads look like they should be re-slurried. So we're gonna extend. It's supposed to be re-slurried every 2 years, but we were told we could wait another year by our road guy. We could extend. They look at like they're decent condition, so we can get another year out of it. No problem. I have no issue with that. That's not failure to maintain. Right. If the roads can actually go another year, because these aren't scientific, 2 years and then it just dies. Right?
There's no imminence to that either.
Exactly. Yeah. But if it's something that has to be, let's go back to the crack, has to be fixed. You don't wait till next year. You can't. You cannot.
Right.
So you go to the reserves. So that answer is never going to work. Okay. Closely related to what we talked about before is downplaying reports.
Yeah.
They talk about the report. They don't fail to disclose it. But let's say you go get it for yourself, and the language in there is a little more alarming than they're making it out. The language is, this needs to be repaired immediately. This could cause a, and they're saying the report, we were told, it may not be in the report, but we were told, we could fix it as long as we did it in the next year or so.
Yeah.
But the report clearly says, or makes it obvious that you can't wait a year. It's got to be happening, right?
We get that a lot, yeah.
We get that a lot. So it's very subtle sometimes. Sometimes it's obvious. Sometimes it's subtle. But it is literally downplaying the urgency in a report by an expert.
Right.
That's a red flag. You don't downplay because that's not honest.
There's a lot of, I've seen both intentional spin and reframing it, and I would say, very purposeful and arguably a malicious one too.
Right.
Yeah.
So bottom line, that pattern, okay, or that downplaying could be just sloppy wording, but most likely it's a red flag here. Mm-hmm. There's two other red flags I want to get through before we can kind of wrap up. One of them is there's a pattern of Band-Aid fixes. So that crack happens. Whatever the cement equivalent of bondoing is, they fill the crack, but they don't actually solve the raised problem.
Yeah.
Okay? Or they prevent the crack from getting bigger, but they don't solve the crack. That's a Band-Aid. Band-Aids are good for short term. That's what Band-Aids are for, short term. They are never should be permanent, okay? If you have a permanent wound, you need to get it stitched. You cannot use Band-Aids. So if you have a pattern of Band-Aiding things and saying, okay, it's done, having the handyman take care of it instead of a contractor to come and fix it, that's a problem. And then the last one is that you see, and we see this a lot. We've talked about this in other podcasts, pattern of special assessments. Mm-hmm. Every 3 or 4 years, you seem to get a special assessment of around the same amount to kind of fix the same things. You know what that means? When you see a special assessment every so often, 2 years, 3 years, 5 years, whatever it is, and it's always to repair this, and it's the same this, it's because they're not maintaining or repairing the this when they should be. So they're waiting until it gets so bad that it has to be replaced or fixed, permanently. All right. That's negligent. You can't do that. So that's a red flag. Okay. Now, what can we do as a homeowner to force action? Well, Sam likes to always talk about documenting. Mm-hmm. Document everything. Keep every email, 100%. Dates, keep a log. Okay. Submit a written demand to the board. You can do a phone call too, but I would do it in writing first. Management company, to the board, whatever. Hey, the paint is completely gone on the gate by the pool and it's rusting. It needs to be repaired. Please take care of it. Or, hey, we have a crack on this walkway. It is a tripping hazard. Please put up a sign or something and then get it fixed.
Yeah.
Put it in writing. Because if they ignore it now, you're just setting up later. If you need to take legal action, you are now increasing the strength of your case by tenfold.
Hey, might as well throw in a reference to 4775 in there.
Even if you don't.
Yeah.
I don't expect a layperson to cite a statute. Just say you're legally obligated to repair, replace, and maintain common area. I'm telling you about a broken common area, and it poses an immediate danger to somebody. Fix it. Or that slope poses an immediate risk to the homes at the top of the hill that we're going to end up having to pay for because you're going to be deemed negligent for not taking care of it. It's going to be especially assessed against me. So even though it's not my house, I demand you take care of it. Put them on notice. From that date forward, it's in writing that they were on notice. They can't ever say they didn't know.
Yeah.
And that's what you want. You want that clock to start. You want to demand access to inspection reports and contracts. So remember that, that person did the walk in our hypothetical, but there's no mention, that red flag, there's no mention of the inspection report.
Right.
Do a 5200 demand that we've talked about in multiple episodes, and we have a whole episode on. Do the 5200 demand and ask for any inspection report conducted on any of the slopes in the last year. Boom. Done.
Yeah.
Get that inspection report, read it for yourself, and then decide whether or not it was a real red flag or not. Okay? And if none of that's working, contact your fellow homeowners. Yeah. Email all of your fellow homeowners. Go door to door if you want, depending on the size of your community. Get them involved. Notify them about it.
Yeah.
And tell them why they should care. If this slope crack extends up and cracks the foundation of that person's home, the HOA is going to be held legally negligent and liable for that, and they're going to especially assess us to pay for those damages and attorney's fees. We're going to be on the hook. Let's save the money. I don't want to be on the hook for a couple $100,000 divided by how many houses live here. I don't want that. Let's avoid it. Get your homeowners involved because that's how you remove a board.
That can be powerful, yeah, engaging.
Very
others.
powerful.
Yeah.
And if all that fails, you call us at MBK Chapman, and I promise you we'll set your HOA straight.
Oh, yeah.
Okay? Bottom line, folks, there are things you can look out for to protect yourself. There are things that you can look out for that we call those red flags. And if you see one or more of those, act. Just do a little bit of investigation. Hold your HOA accountable. It's not hard. You have all the tools you need to do it. We talked about a lot of them today. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to the channel. If you want to leave a comment, we're always very happy to hear from our listeners. And until next time, please have a wonderful day.